Commission meeting for November 13th, 2025 to order. And the first item on the agenda would be the adoption of the agenda.
I saw moved.
Good.
Well, we need a roll call vote on that, please.
All right, Commissioner Gilroy. You agree?
I agree.
Mr. Noel,
Agree.
Mr. Duncan. Agree. Mr. Kennedy.
Agreed.
Okay, motion carries. The agenda is adopted. The next item on the agenda would be the approval of the minutes of October 9th, 2025. Commissioners all received a copy and had a chance to review those. Okay, are there any additions or corrections?
And I so move approval.
Sure.
Okay, may we have a roll call vote, please?
Commissioner Gilroy,
Accept.
Mr. Noel,
Agree.
Mr. Duncan. Agree. Commissioner Kennedy.
Agreed.
The next item on the agenda is the consideration of the post-employment waivers. Our first post-employment waiver is Indiana Department of Workforce Development regarding Marilyn Pizzulo, presented by DWD Ethics Officer Amy Durfee. May we please have a brief reading?
Absolutely. Amy Durfee is here on behalf of DWD's Employment Authority to present this waiver of the cooling off provision regarding regulatory and licensing decisions to allow Ms. Pizzulo to go work at Pennsylvania. Now, I know that Ms. Pizzulo let us know this morning that she couldn't attend, so Ms. Durfee is here.
And by statute, that is acceptable.
Yes.
Okay. May we please have the witness sworn?
Raise your right hand, please. Do you swear that what you're about to say is the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you. Can you just please state your name for the record?
Amy Durfee.
You may proceed. Thank you.
Thank you. I just have a brief statement. I'm here on behalf of DWD former employee Marilyn Pizzulo. She retired on November the 7th of this year. She's seeking a post-employment waiver. Ms. Pizzulo has worked for DWD for 15 years. During her time, she has worked as an associate chief and headed up the agency's adult education program. The program includes preparing adults without a high school equivalency diploma to test and receive that diploma. She has been involved in funding of the adult education providers. The Indiana Adult Education Program grants state and federal funds to providers to offer the adult education training services. Central 9, the employer in question here, is one of those providers. It is also a testing center for the high school equivalency test. It contracts with HiSET, which also has a $0 contract with the state. Students seeking a high school equivalency diploma pay Central 9 to test for that diploma. Then Central 9 pays HiSET for a set amount per exam. It's very Russian nesting dolls here. Ms. Pizzulo has worked for Indiana's public servant for numerous years. She has developed important skills that will gain valuable experience during her time as public servant. The public will continue to benefit from Ms. Pizzulo's experience if she begins employment with Central 9. She is seeking to fill the void of a test proctor for the high school equivalency exam. If she is not granted this waiver, she will be losing out on the opportunity to help Hoosiers seeking their high school equivalency exam, as test proctors are kind of hard to come by at the moment. She is taking great care in both her previous role and in her next steps to maintain the highest standards of ethical and professional conduct. She received and filed a conflicts of interest waiver on October the 16th, since she was involved in the funding of the adult education program. She oversaw employees that handled that and handled the compliance of it. She was not immediately involved in it. It is our sincere belief that her proposed employment will not impair the integrity of the state's operations or undermine public confidence in the separation of her past government duties and her future private sector involvement. We appreciate your consideration here.
Thank you. Commissioners, any questions?
I was wondering if Ms. Pizzulo
Yes.
had access to any confidential proprietary information that might be helpful.
I don't think she was involved directly in the RFP. She oversaw the employees who actually went through with it and made sure that their compliance efforts made sure. She has been made aware of the confidentiality portion of the state ethics, and she will maintain that level of confidentiality if there is anything.
Will she have any interaction with DWD employees in this new position?
Very unlikely. I'm not sure how often the high school equivalency test occurs, but as a proctor, any compliance issues would be dealt with Central 9 and the DWD employees. It would not involve the proctor itself unless there was some outrageous incident that occurred, but those rarely happen because I haven't seen them yet.
Well, with all of her experience, there might be a chance that she would change jobs within Central 9. If that were to happen and it would give her more contact, how would that be handled?
She would then have to reach back out to me and we likely would seek a different post-employment waiver because of the more involvement that would occur, because it's such a test proctor position. I did not get a chance to confirm if it's a W-2 or a 1099 type of position. But it seems more as an as-needed basis. So if it were to become something more formal, I will be able to step in and advise her, and we probably would seek a second waiver based off of the new position and the new information that would be required. Thank you.
Commissioners, any other questions or concerns?
I move for approval of this post-employment request.
Do I have a second?
Second.
Okay, may we please have a roll call vote?
Commissioner Gilroy? You agree?
Agreed.
Commissioner Hall?
Great.
Commissioner Duncan? Agreed. Commissioner Kennedy?
Agreed.
Motion carries. The post-employment waiver is approved. Thank you.
Thank you.
The next item on the agenda is the consideration of a post-employment waiver regarding Indiana Economic Development Corporation regarding Kyle Gaddis, presented by DWD Ethics Officer David Staples. May we please have a brief reading?
Yes. Chief Ethics Officer David Staples is here on behalf of IEDC's appointing authority to present this waiver regarding the cooling off provision related to contracts to allow Kyle Gaddis to go work for McGuire Farm.
Okay, may we please have the witnesses sworn?
Raise your right hand, please. You swear that what you're about to say is the truth, the whole truth, and nothing but the truth?
Yes,
And can you both please state your name for the record?
Kyle Gaddis.
David Staples.
May I proceed?
Morning, Commissioners. My name is David Staples, and I'm the Deputy General Counsel and one of two ethics officers for the Indiana Economic Development Corporation, which I'm going to refer to for brevity's sake as IEDC. It's my honor to appear before the Commission today to seek approval for a post-employment waiver for IEDC employee, Mr. Kyle Gaddis, who's sitting next to me, I should say. Mr. Gaddis has given almost 8 years of service to the state of Indiana vis-a-vis the Economic Development Corporation. But prior to that, he was also employed directly by the state as an attorney for the Department of Child Services. Today, Mr. Gaddis is requesting a waiver of the 365-day cooling off period so that he may pursue outside employment with McGuire Sponsel LLC. Currently, as the Vice President of Account Management, Mr. Gaddis oversees the account management team, a compliance manager, and an auditor. Collectively, I'll refer to as the account management group, which administers thousands of tax incentive projects the IEDC has with companies across Indiana. I want to note that the account management group and Mr. Gaddis are not responsible for the decision to award tax incentives. That's outside of his group and outside of his purview. It's handled by a separate division of IEDC. However, Mr. Gaddis did oversee the department's responsibility for contracting, compliance, and reporting. Mr. Gaddis was not involved in the day-to-day administration of tax incentives, which was handled by the account management group. Mr. Gaddis, who is a lawyer, was consulted when changes were requested to the template tax agreement. It's a form agreement, but if there were red lines, Mr. Gaddis would be, his legal expertise would be sought. He was also involved in secondary review of payments or when other legal questions arose. Although tax credit certification letters bore Mr. Gaddis's name, he did not personally review the reports or issue the certification letters. His signature on there was more of a formality from the IEDC. After review, Mr. Gaddis was only able to locate a single McGuire Sponsel project that he had any interaction with. This was in November of 2019. Mr. Gaddis provided a secondary review of a training grant worth approximately $10,000. He has agreed to screen himself from this matter at McGuire Sponsel. I also want to add that in addition to the state code and Indiana's ethics responsibilities, as an attorney, Mr. Gaddis has additional ethical responsibilities to continue to screen for conflicts under Indiana rules of professional responsibility, specifically 1.7, 1.8, and 1.9. We asked the Ethics Commission to note that this waiver request is aligned and consistent with the service Mr. Gaddis has provided to the state of Indiana for many years. This future employment will help ensure compliance with Indiana's tax laws, while also giving clarity to businesses to help them flourish. I also want to note too that the state has established a separate commission to deal with the attorney shortage in Indiana. And so I think his ability to contribute would help Hoosiers in that way too. Mr. Gaddis's future practice at McGuire Sponsel will focus on local taxes, property taxes in particular. And in that regard, doesn't anticipate any interaction with IEDC or IEDC projects. To the extent that a conflict arises, Mr. Gaddis will take appropriate measures to screen himself in that matter or seek the board's further counsel. I conclude by stating that as Indiana's economic development engine, IEDC touches thousands of businesses across the state. That's the point. And that IEDC has incentive agreements with over 2,700 firms in the state. Additionally, IEDC engages many of the state's top law firms as outside counsel. So should waiver be denied, Mr. Gaddis's future employment options would be critically limited. And then in turn, his ability to support himself and his family would also be in jeopardy. So for these reasons, I respectfully ask the commission to grant our post-employment waiver request. And I thank you for your time.
Commissioners, any questions, concerns?
You, at this point, have no plan of interacting with IEDs.
Correct, yeah.
If that should change, what would be your plan of action?
Well, if the scope of that employment would change, I would have to consult with the State Ethics Commission. From that standpoint, it's currently going to be property taxes. So, and it's a nationwide practice. So it's the
Sounds
scope
like
of
a
what.
rare possibility.
Yeah.
Thank you. So moving.
Second?
Second.
Okay, may we please have a roll call?
Commissioner Gilroy,
I agree.
Commissioner Knoll,
Agree.
Commissioner Duncan. Agreed. Commissioner Kennedy.
Agreed.
Motion to use the post-employment waiver is approved. Good luck. Thank you for your service.
Thank you.
Thank you. Next item on the agenda is the consideration of the formal advisory opinion regarding the Indiana Department of Homeland Security, specifically Julie Smith, which is presented by Indiana Department of Homeland Security Deputy General Counsel and Ethics Officer Christy Shute. Okay, apologize for that. May we please have a brief reading?
The Department of Homeland Security has requested the commission's advisory opinion regarding Ms. Smith's situation, basically seeing how the code would apply given her new role as OSS director in relation to some of her outside professional activities and her husband's appointment.
Thank you. May we have the witnesses sworn?
Raise your right hand, please. Do you swear that what you're about to say is the truth, the whole truth, and nothing but the truth?
Yes. Thank you. Can you please both state your name for the record?
Julie Smith. And I'm Christy Shute.
Thank you. You may proceed.
Thank you, commissioners, for taking the time and for meeting with us today. As I stated, I'm Christy Shute, and I am the ethics director or officer, for the Department of Homeland Security. Homeland Security has various subject matters under its purview. But one of the new initiatives that we now have based on the past legislative session is that the Office of School Safety, which is Julie is the director now of, is housed within our agency. Previously, it was under the Indiana Department of Education, and it's moved over in this last legislative session, so it's very new to our office. This office is involved in a lot of initiatives, but the overall umbrella is that it's responsible for coordinating and administering school safety resources. So that includes training school resource officers and other, like I said, a lot of other initiatives. As part of that transition to our agency, our office hired a new director. So we went through that process to find someone to lead this office, and Julie was picked as that director. And I want to be clear that during the entire hiring process, Julie was transparent about her professional affiliations. And now I want to discuss those professional affiliations. Julie has a background as a law enforcement officer. She's a former sergeant with the Columbus Police Department, where she oversaw the School Resource Officer Division and acted as a school resource officer for the Bartholomew County Schools. She's also the affiliations that are, I think, particularly important are the Indiana, let me get this right, School Resource Officers Association, which I'm going to refer to as INSROA moving forward, and then the National Association of School Resource Officers, which I will refer to as NASRO moving forward. So with INSROA in the past, the Department of Education would seek their input regarding appropriate speakers for various trainings and conferences. And that's the approach that DHS intends to take, that we'll ask INSROA for their advice and their preferences for speakers, but we will not contract directly with INSROA. We will contract directly with those speakers. As far as Julie's affiliation with INSROA, she is the past president of that organization. In their bylaws, it states the duties and rights and responsibilities of an immediate past president. And that includes voting rights and being on the board of directors. However, Julie has made it clear to INSROA that she has relinquished those rights and she's not going to vote and she's not going to be on the board of directors. She can't undo the fact that she's an immediate past president because she was the president. She also retains a lifetime tenure and honorary membership with that organization. Anybody, as long as they're associated with school resource officers and a law enforcement background, can be a member of INSROA as long as they pay a $50 membership fee. And DHS likens that and to be similar to attorneys that can be members of like a professional bar association. We pay the fee, we're a member, but we don't have any actual say-so in how that organization is run. And that's our perspective of what her membership conveys to her. She's also affiliated with NASRO. NASRO, just like with the Department of Education, did contract directly with NASRO, and DHS intends to do that moving forward. And I'll explain in a minute why that's important. And really, based on statute, we feel that it's the only agency that we can contract with. So we intend to contract directly with NASRO. Julie, again, is a member of this organization. She must maintain her membership to have access to instructor materials. And like INSROA, if you're affiliated with police officers or school resource officer training and you pay your $50, you can be a member. She's also an instructor. She's not employed by NASRO, but she acts as an independent contractor. In the past, she received compensation for those services, travel, lodging, and meals. However, if the commission approves her to be able to continue as an instructor, she will not receive compensation for those services, and DHS will pay for her travel, her lodging, and her meals. Similarly, her husband also has a background in law enforcement. He is the chief of the Decatur Township Schools Police Department. And he also, related to INSROA, is a member, and he is the training director, which does put him on their board of directors. Again, however, we don't think this is implicated because we will not be contracting directly with INSROA. With NASRO, he is also a member. He is also an instructor, and it's the same setup. He is not employed by them, but he is an independent contractor. He does receive compensation for those services, and they do pay for his travel, his lodging, and his meals. Further, he is the Region 5 director, which puts him on the board of directors and gives him voting rights. And they do vote on things such as, and Julie can speak to this more than I can, such as where they're going to hold their national conference every year. I do want to provide a technical correction, and this goes into why we think we can only contract with NASRO, and this is a correction to my submission to the commission. There's an Indiana statute that says that school resource officers have to receive 40 hours of training before they can be designated as a school resource officer. And that statute says there's 3 categories of entities that can provide that training. One is the Indiana Law Enforcement Training Board. One is NASRO, it is specifically stated. And then the third category is another school resource officer training program that is approved by the Indiana Law Enforcement Training Board. And in my submission, we thought there was only one other program that was approved by the board. We've since learned that there are others. From our perspective, NASRO is the gold standard. They are certified by the International Association of Directors of Law Enforcement. and all of these other associations that I'm going to, describe are not certified by that organization. So other entities that are approved by the Indiana Law Enforcement Training Board are the Association of Chiefs of Police. To our knowledge, however, they've never taught a class, and it's believed that they've never even developed a curriculum. Further, Ivy Tech has provided some classes, but we don't believe it's a very robust program. And then thirdly, Perry Township Schools Police Department has a program, but it's our understanding they just provide that training to their own officers that they want to designate as school resource officers. Two other things of note that I think are important in the analysis. The Department of Homeland Security manages the Secure School Safety Grant. That is a state-funded grant through the legislature every 2 years in the budget. But it's managed internally by our DHS grants team, which is separate from the Office of School Safety. Usually, each applicant is going to get funded their first choice. So we don't really use a lot of discretion as far as scoring and putting a better application over another. Usually, like I said, usually everyone gets funded so long as they are an eligible entity to apply and they've picked an eligible project. So once that data is collected internally by the DHS grants team, it is presented to the Secure School Safety Board. Julie is chair of that board. It's an 11-member board, and essentially we present the information like, here are all of the eligible schools, and usually the board approves that recommendation without any changes. This is important because Decatur Township has received this grant since its inception, except for 1 year when they missed the application deadline. And her, like I said, her husband is the chief of Decatur Township Police Department, school police department. It's okay. The one other thing I think that's important to note is the DHS contracting process in general. I am the contracts attorney for the agency, so I work closely with who I consider project managers regardless of their title within the agency. And in this case, I'll be working closely, assuming we can move forward with Nazareth, on developing that contract for content to provide the 40-hour basic course that these SROs need to become SROs. I make the ultimate call regarding boilerplate clauses such as indemnification or insurance, those types of things, termination for convenience, but she will be heavily, I'll rely on her regarding the deliverables. I'll make sure they're in the contract. We'll have that dialogue about what needs to be in there. So I will be working closely with her and her office to do that. But like I said, ultimately, I make the call on what is the final product. And I don't sign those, and neither does Julie. So based on this, and Julie can discuss more about all of her affiliations, we ask that you can give us advice on if any of the ethics rules apply, and if so, how they apply. I appreciate your time. You probably all have a few questions.
I guess my first question is if we focus in on Nazro, obviously both Ms. Smith and Mr. Smith have a financial interest in the contract with OSS and Nazro.
I would argue that, what was that?
I mean, they're both instructors and I'm assuming they're compensated for their instructor activities.
She will not be, if we're allowed to move forward, she will not be compensated for her instructor. If we're allowed to move forward, and that's one of our concerns, is that her husband's professional development could be stunted if he's not allowed to move forward as an instructor. Are you speaking specifically regarding the decisions in boats conflict, or?
Well, I just think the fact that OSS, because they contract with Nazro.
The intent to, we haven't yet.
Okay, they would be receiving a financial benefit, but what you're telling me is they would be able to instruct, but they wouldn't be compensated for that?
She will not get any compensation ever from Nazareth, regardless if it was from our contract or any other entity.
Okay.
And we will not hire her husband for our trainings. So he can go throughout the rest of the country on behalf of Nazareth and get those things.
Okay.
But not based on our contract.
That clarifies things for me substantially.
Thank you. Sorry for that
I
oversight.
asked about your plan for recusal and your disclosure and all of that, but you're saying you would not do work here
That's our proposal.
with OSS.
Yes, from my perspective, I don't think there needs to be a recusal because there's 4 categories to that statute. If the state officer, firstly, the employee has a financial interest, and I think she's excluded from that because she's not going to receive anything from NASRO. Like I said, she won't accept compensation and DHS is going to pay for her travel. The member of her immediate family is her husband, but we aren't going to hire him as part of our contract to provide training in Indiana. He would have to go to other states to do that.
Is he presently hired?
Yes.
Presently do that?
And he's an independent contractor, but yes, and you can speak more to that.
Right, so the instructor process, it's extensive. There's a lot of work that goes into this. And instructors, as they choose a class, so NASRA will post training opportunities that happen throughout the country. And as contract employees, we will, instructors typically just submit a request to teach that particular training. So as we're hosting trainings on behalf of the Office of School Safety, he just won't put in to teach those trainings, and thus he will not be assigned to do that.
Will that be a big loss or inconvenience to him?
Well, there's 57 instructors in the country. And with that, I mean, there's plenty of opportunities for him to teach in other states if needed. He does wish to still teach in Indiana, just obviously not if it's a conflict of interest as the OSS is hosting these.
And you're going to remain an instructor,
I would like to remain an instructor, yes.
but you would not get compensation. You get paid by, you just be part of your job.
Correct.
It says.
We would consider these duties to be part of her DHS duties, so there wouldn't be any concerns with ghost employment or use of state property, because it's our contention that it helps her to maintain those relationships, continue to learn best practices, and have those affiliations so that we can provide the best program for our school resource officers in Indiana. So yes, again, she won't be compensated by NASRO, and we will pay for all travel, lodging, and meals.
And doing that keeps me updated on the cutting edge information that's coming out in school safety. NASRO partners with only the best in the business, and having the opportunity to be in those rooms and learn that information, but also get to be in the classroom with the new school safety professionals in this state. I think that's an important thing for this office to build trust and build community as we're getting out and with this new office and just preaching these best practices. They can see it from us directly.
Mhm.
I have several comments whenever you're ready, Madam Chairwoman.
Please go right ahead.
Thank you. I think I read over these materials 3 or 4 times. And before I start bumping into all the trees, I think we need to take a couple of steps back and look at the whole forest here. And I'm kind of channeling our former colleague, John Kraus, who often asked at our meetings, what would this situation look like to a taxpayer or a member of the public or someone in this kind of business? And I have to say that I disagree with certain aspects of the proponent's analysis. For starters, you know, there's this parsing of who is a member and what is a member and why the proponent's definition of membership would not apply. I think that's wrong. I think the statute speaks to serving members. The word is not modified by voting, paid, or anything else. And I don't think that Ms. Smith can avoid being considered a member simply by saying I'm giving up my voting rights to this one organization. Secondly, the definition of employee includes independent contractor in the statute, as I understand it. And this parsing of independent contractor versus employee, I don't think, at least according to what I've read, you know, doesn't save anything here. And it seems to me that there are conflicts of interest all over the place here. And the solution is not, in my opinion, for this commission to adopt some kind of strained or difficult definition in order to find that there is no conflict. But I think the solution to this stuff is that as these conflicts arise, Ms. Smith files a notice of conflict of interest as required by state law, and then she is screened from anything to do with these various conflicts. You know, the last part of this, if I'm reading it correctly, the organization her husband works for gets grants, and how you can say that he doesn't have a financial interest in that is just kind of beyond me. And so I just don't see how we can adopt this strained reading of the statute in order to allow all of this to take place. And that's all I'll have to say. Thank you.
Let me ask a question here. There are two organizations involved. Now, the Indiana School Research Officers Association, as immediate past president, you would have certain voting rights and all that, sit on the board of directors, and you've relinquished that.
Yes, sir.
So you're not going to have any role in director of decisions at this organization. So that's really all we're talking about with respect to that organization, correct? Is there anything else?
And to be clear, the DHS does not intend on contracting with them. We will just seek their advice and opinion on what they
Right.
think for speaker.
That's
Correct.
in other words.
There's no financial benefit.
There's a recommendation. You think the speaker would be good, and OSS contracts with that. So I don't see any kind of conflict situation there.
Could I add something to that? I just want to be completely clear that every year, the Indiana School Resource Officers Association hosts the Indiana School Safety Conference. That's been going on for probably 20 years now. And the Department of Education, when school safety was under the DOE, they paid for those speakers for NZROA. So they would contract, I say not contract's the wrong word. They would collaborate together to determine the needs of Indiana school safety professionals and offer school safety specialist credit, which is now the responsibility of our office. So they would collaborate together to determine what speakers Indiana needed to hear, and the DOE would pay for those speakers, not NZROA. They never wrote a check to NZROA, but rather pay those speakers. And
They just collaborate to come up with who the best speakers are for
Exactly
that
right.
situation.
That's exactly right.
And then direct contract and the OSS with the speaker.
That is correct.
Say, I don't see.
I agree. I don't think there's a conflict or a situation with Israel.
Now let's talk about the other. The National Association of School Resource Officers. You and your husband are both instructors.
That's
With respect to you, OSS is taking the position that your involvement with that association is now part of your job, and you won't be compensated for by the association for your instructor talents, and that OSS will also pay any travel subsistence, that sort of thing.
Correct.
When you go out and perform instructor services.
Yes, sir. I gave up all of that whenever I took this position, understanding very quickly that it would be a conflict of interest. I met with her very early on, and even throughout the hiring process, I was very transparent that these are things that I'm affiliated with, which also got me to a position to where I could speak intelligently to school safety and the things that I've led, initiatives that I've led, and not just this state, but in the country.
Okay. And you would be a member of both of these organizations just by virtue of paying the dues.
Yes, sir.
Okay.
Except NZROA is an honorary membership because of my, I was president of that organization for 3 years. So
Okay. All right. So is the focus here, should we be focused primarily on your husband at this point?
I think we need to talk about MSD.
I think we need to avoid any appearance of favoritism
Yeah.
or undue influence. But you say that he will never have any involvement here. He will not get paid to be a trainer in Indiana. We did not hire him.
Not from our contract. It's my understanding that he could do other trainings in Indiana that's not paid by the Department of Homeland Security contract. And we will not hire him as an instructor.
and
In
then
other words, OSS will not have any involvement with any contract involvement in this business.
the OSS doesn't employ the instructors, NASRO does. So the NASRO training director, they decide who the instructors are, but in our contracts with them, we can make them understand
We're
that
gonna screen out your
that's
husband
exactly right.
from any NASRO contract regarding Indiana.
The ones that the OSS contracts. And to be clear, we are only in this next, I'll say before the end of the fiscal year, we intend to do 3 basic SRO classes. So there's only 3 classes that we're talking about here that my husband is even eligible to teach. And I will ensure that that does not happen.
And is there, I think there should be an expectation that every year you re-review all affiliations and everything just to protect the appearance of any favoritism, undue favoritism, I guess, or involvement,
We're happy to do that.
as long as she remains head of OSS.
I actually personally see an overall benefit
And that's our,
OSS involvement
Agreed.
directly with these 2 organizations. This is, in my viewpoint, critically important, the safety of children in school. I don't disagree that there's a potential appearance of a conflict. But in my viewpoint, as long as it's transparent, fully disclosed, regularly updated, if any issue comes up, it's promptly dealt with. And everybody that needs to know, including the public, that we acknowledge there's this apparent potential conflict and the steps that have been taken to mitigate any conflict. I can support that.
If I can add that other states that have an office of school safety or a substantially similar office that have been very successful, have partnered with NASRO. There's Delaware, Utah, Colorado, Arizona, Texas, Florida, Indiana hosted the 3rd largest national conference for school safety in history. And that was in 2023. And that was also a partnership with NASRO before this office was even established.
and we're happy to follow disclosure statement stating, and we're happy to follow disclosure statement stating that when we enter into a contract, assuming it's approved with NASRO, that her husband will not be an instructor for anything financially supported by the Office of School Safety or the Department of Homeland Security.
Say, you don't want to lose Ms. Smith's experience, particularly training, because she now has a position that some degree of oversight, I suppose, but pretty comfortable when everybody acknowledges that there's could be, somebody could experience interference and that you take all necessary steps, mitigating the conflicts and acknowledge if conflict presents itself and deal with it accordingly. In other words, consider yourself under a microscope.
I guess that's one of my concerns is with the MSD contract. How do we avoid the appearance of impropriety with your husband being the chief of that program?
If the structure of how that works, her team's completely screened off as far as how grantees are chosen. That's a separate grants team who reviews the applications. And like I said, from a practical standpoint, as long as you're an eligible entity and pick an eligible project, you're going to be funded. So there can be discretion, but the office usually doesn't use it because we want to make.
He's not making that determination in any way whatsoever.
She's not involved in that initial determination. It is determined by grant staff, and then that grant staff presents it to the school's Secured School Safety Board, which she is the chair of. So then that 11-member body votes to approve that recommendation, reject that recommendation, or make tweaks to that recommendation and then approve it. So she could be involved in the vote. Because there's 500 plus applicants.
We can't exactly. Could you recuse from that specific?
She should recuse herself from
We
that.
can have her, and we can file that disclosure waiver as well, that when the board meets to vote for who's going to receive funding, that she steps out of the room. Or if we can even go further, if you like, and have someone else chair that entire meeting and not have her participate in that meeting whatsoever. Whatever you think is the best approach forward, but thankfully we have 11 members, so someone else.
Yeah, I
should have
don't think that she needs to necessarily avoid the entire
Okay.
meeting, but I think that's inappropriate for her to vote on that.
Okay.
If they are one of the potential.
They probably will be.
Okay.
Yes, because
She should be.
yeah, they've received it every year since the program's been in place, except for 1 year where they missed the application deadline. So in practice, most likely, yes.
Well, then, the other fact is Nazareth is the only approved provider, correct?
From our perspective, from a practical standpoint, yes, there are other approved providers, but their programs are not robust enough to provide the 40-hour basic course across Indiana.
It's the only one approved by Indiana, correct?
They're specifically named in that statute as one of the 3 categories that can provide the training. So from my perspective, the legislature realized and recognized that this agency was an important provider of the service and specifically named them for that reason.
Commissioner Finnerty, do you have any other comments or concerns?
Well, I apologize for not being there, and perhaps my hearing on the phone is not as good as if I were there in person, but it seems that this discussion has sort of gone in a direction that it sounds to me like the proposal now is, or that we're not being asked to, or are we being asked to find that there is no conflict of interest, or conversely now, are we being told that that Ms. Smith will file the standard disclosure of conflict of interest forms and that she will be recused from any kind of voting or decision-making regarding her husband's township school district or whatever it's called, grants, that he will not be eligible to teach and receive payment from her department. Is that what I'm hearing now, that the proposal has changed?
I think it's the same, actually. It's just a clarification of all of those stop gaps to assure to assure no appearance of favoritism or influence.
I agree. I mean, I think that it's been very well thought out and presented. You understand the pitfalls and the potential conflicts, and have come up with a game plan or a strategy to avoid those and avoid, the appearance of impropriety, avoid the conflicts that are potentially there. And as stated, I think it's a well thought out game plan or strategy.
I appreciate that. And to answer your question, we will do whatever the commission thinks is most appropriate. We want to be collaborators and work together. So that she can still teach these classes and be part of these, professional affiliations.
I mean, I don't see any issues whatsoever with NSROA at this point in time. There's no contract,
Correct.
in place. Regarding NASRO, she's not being compensated. That's gonna be part of her role with the state.
Correct.
And that benefits the state. You know, I originally was worried that she was gonna be instructing and compensating, and that would be a huge problem for me, but you've clarified that. So at this point in time, I don't see an issue with NASRO. And with MDS, if you recused from any voting situation that they would benefit, financially from the state, I think that the Ts are crossed and the Is are dotted.
You know, I agree. This filing a conflict of interest. Does that need to be a part of it? I'm not familiar with this form, but I think if that even better clarifies publicly, she recognizes the potential, then I think she probably should do that.
So for MSD, what I'm hearing is that you guys are finding that there is a conflict of interest, so she's going to need to recuse herself and file that
Yeah.
disclosure, which will include a description of the conflict in the screen. So
Yeah.
that,
Well put, yes.
Yes, thank you.
We're happy to do that.
Okay,
so just for maybe some technical, going through all of the rules that maybe apply, if we can get a discussion on the moonlighting rule, specifically for NASRO, and, whether or not she can hold both positions, though what it sounds like is that that is now part of her DHS
but
job.
that's solely your duties part of with DHS, correct?
Correct.
Which I think that solves that problem.
Perfect. And then the question of whether there's an interest in a state contract under 426-10.5, the NASRO contract, which she will not be paid.
Which,
It's my contention that it doesn't apply because as Reagan stated, Julie will not have a financial interest in that contract, but just out of an abundance of caution, I wanted to put it in my submission to you for analysis.
And also for clarification that I will not, the class is 40 hours and that's in the SRO statute itself, that it's a requirement for SROs to have that. That in my instructing and the state allowing me to do that I will, of those 40 hours, I will be in the classroom, probably 16 of them because I have an office to run. So I go there, I teach a couple of key things and updates with the OSS. And then I likely won't even have time to be there all week. But the NASRO has agreed to allow me to keep my instructor certifications, even though I'm not teaching the whole 40 hours at a time.
and then, I mean, and we did clarify that, your husband's not going to receive any compensation from NASRO from the contracts with the state.
Correct.
Okay,
We will put that in the contract.
that clarify that?
So you're finding that she does not have an interest in the
Correct.
contract. And then the last one, I think you guys asked about the gifts rule and whether his compensation for NASRO could be an issue under the gifts.
Compensation and his travel expenses, because we're concerned that maybe technically under the rule, it wouldn't be allowed, but it could potentially curb his professional development Because it doesn't make sense from a practical standpoint for him to not receive compensation for, especially if he goes out of state and he travels, and he doesn't get paid for his time, and he has to pay his own way to get there. So that's a concern for his professional development growth.
And again, anytime we host a class, the OSS, he will be exempt from being able to receive, even though the funds go to NASRO and they pay the instructor separately, he will be exempt from the ability to teach any of those classes.
Right, so, I mean, if he's not gonna be compensated by the contracts from the state in any way whatsoever.
No, but he still can be compensated by NASRO based on my reading of the gifts rule where it says the state employee or their spouse.
They have him go teach a class in Kentucky.
Correct.
Right.
That they would pay him for his services, which I don't think falls under the gifts rule unless compensation is considered a gift. But his travel expenses are part of that too. And from my perspective, that is excluded or included in the gifts rule, so he wouldn't be able to accept those. If he goes to Kentucky or anywhere else that's not associated with Indiana, and that's a concern because he would have to pay out of pocket to continue to be an instructor for NASRO.
So we do have some precedent that kind of speaks to this, so it's not exactly the same issue, but there have been previous formal advisory opinions that found that a spouse's compensation, which the specific formal advisory opinion that I'm thinking of included allowing the spouse to bring their state employee spouse with them, travel expenses paid to a conference. And the commission found that that was part of that spouse's compensation and not a gift. So that.
Yeah, I think I recall that specific situation. Yeah, I mean, I guess there's a question for me. I mean, if you're being compensated to go to Kentucky and teach a course, and there's compensating you by giving you X amount of dollars for speaking, and they're compensating you by giving you a hotel room and giving you a food allowance. That seems to me like compensation and not necessarily a gift. And that's
Okay. We appreciate that. Thanks. Thank you.
That's part of the trip.
right.
That was my whole list.
Okay. I have a motion.
Move approval, consistent with our discussion.
Do I have a second? All right, may we please have a roll call vote?
Commissioner Gilroy? Do you agree?
Agree?
Commissioner Knoll?
Agree?
Commissioner Duncan?
Agree.
Commissioner Kennedy?
Agree.
The motion carries. And thank you both very much for your presentation and for everything you do.
Thank you.
Thank you very much.
Okay, the next item on the agenda is the consideration of the 2026 rulemaking.
So really just wanted to open the floor for you guys if you had any suggestions or if, you know, you saw any gaps and wanted to consider potential rulemaking for 2026. I don't have any recommendations though at this time.
No.
Commissioner Finnerty, do you have any thing regarding the consideration of any 2026 rulemaking?
No, I do not. Thank you for asking.
Okay, so we don't need to make a motion on that. We'll just move on to the next item on the agenda. And the next item on the agenda is the scheduling of the State Ethics Commission meetings and meeting dates for 2026. And commissioners, we've all received a list of those dates. Do we need to have any discussion on those dates, or can we approve them?
I appreciate that they're made a year in advance. They're always the second Thursday of each month, and I put them on my calendar. There may be conflicts that arise for me during the year, but I didn't see it.
It is nice to have them in advance.
Makes us a priority.
Okay, do I have a motion to approve the dates for
I so
2026?
approve.
Do I have a second?
Second.
Okay, may we please have a roll call vote?
Commissioner Gilroy?
Agree?
Commissioner Knoll?
Agree?
Commissioner Duncan?
Agree.
Commissioner Finnerty?
Agreed.
Motion carries. The dates for 2026 are adopted, and the final item on the agenda is State Ethics Commission Director's Report. Madam Director.
All right, so we had 15 informal advisory opinions that the OIG issued since the last meeting. Most of those have been finding and post-employment, which is consistent with what we've seen for the last several months. I do want to introduce our new OIG attorney, Rachel, and our new member of the investigative team, Cassie. So just
Welcome, Rachel and Cassie.
Do they have last names?
Gallagher and Doss. And then finally, our legal ethics conference is next Thursday at 1 o'clock in the Government Center auditorium. 3 CLEs, 2.3 of those are ethics, so if you're any attorneys, it's definitely a nice perk, and that is all I have.
Okay, thank you very much.
You mentioned that, you were gonna wait till the December meeting to discuss the electronic meetings policy with the new live streaming.
Yeah,
It seems like that is gonna change that policy.
yeah, I agree, so I might
Are you gonna present
draft
something to us?
hopefully, just spend a little more time on it.
Thank you.
Anything else, commissioners? Okay, that was the last item on the agenda. I would entertain a motion to adjourn.
So moved.
I have a second.
Second.
Okay, may we have a roll call?
Commissioner Gilroy,
I agree.
Commissioner Knoll,
Agree?
Commissioner Duckett, Commissioner Benardi.
Agree.
Okay, motion carries. This meeting is adjourned.
Thank you.
Thank you.
Yes, Fran.
Yeah, that was fun.